And I would suggest actually to give the floor to Lee Toomey, because her presentation will somehow complete in details what Laurel has anticipated. So this could help also to stimulate some questions. As Sami has already said, we are very pleased to have her with us today. I will provide some quick information. She is the chair of the UN Working Group on Arbitrary Detention since August 2015, and she has served also as vice chair on follow-up. She has taught human rights and criminal justice reform at the Queensland University of Technology and for the Royal Wallenberg Institute of Human Rights and Humanitarian Law. She is qualified as a solicitor in England and Wales and as a barrister in Australia. Her experience includes intensive field-based work in developing conflict and post-conflict settings worldwide for UN agencies, NGOs, academic institutions, and development organizations. So thank you very much for being here with us. Thank you.
Thank you very much for that kind introduction. Can you all hear me? Great. Well, as was mentioned, my name is Lee Toomey. I'm the current chair of the UN Working Group on Arbitrary Detention. I just want to commence by thanking the organisers for putting on this wonderful webinar today and for the invitation to join you all. It's a real privilege, and this is a really important topic, not only for everyone to hear about, but for a chance for me to tell you a little bit about the working group's work on this issue. A few words, first of all, to complement Laurel's presentation about the special procedures. As she mentioned, the UN Working Group is one of those special procedures, and it's composed of 5 members from around the world. Each of the 5 regional groupings, Western Europe, Eastern Europe, Africa, the group of Latin American and Caribbean states, and Asia Pacific are represented on our group. So we have 5 members. We sit in Geneva 3 times a year, usually April, August, and November. At the moment, all of our work is going on virtually, as you can imagine, because of the pandemic. Some of the important functions that we carry out, Laurel adverted to, but let me talk a little bit more in detail. Unlike other special procedures, the working group has a particular function of adopting opinions on cases that are brought before us. We call that our regular procedure. So let's say there's an alleged human rights violation involving detention of someone. It could be the detention of a conscientious objector to military service in a particular country. We have people bringing those cases before us, which we consider when we're in session in Geneva, and we adopt an opinion. Every year we adopt about 80 to 90 opinions, so it's quite a heavy workload, but we find it probably the most effective aspect of our work because it allows us to really engage on specific issues and to set the working group's jurisprudence on particular issues. We also issue what's known as urgent appeals and allegation letters, which is a little bit quicker process. It involves writing in a confidential manner to states with allegations, just to find out in urgent situations what's going on with someone in detention. And we often join with other special procedures mandate holders in doing that. Thirdly, we carry out country visits to states involved. Laurel mentioned those. Those haven't been going on right across the special procedures at the moment because of the pandemic, but will hopefully resume in the second part of this year. And finally, we write deliberations, which are like the general comments of treaty bodies that set out the law on different aspects of our work. You can find all of this information on our website, and I'll give it to Laurel as well to make available to you. So that's a little bit about our work. I thought you might be also interested, which I can address perhaps at the end of this presentation or during the Q&A, on how civil society can engage with the working group as well. So I'll be happy to give you some information on that. In terms of our thinking on conscientious objection to military service, I think it's fair to say that the working group's work has evolved over the years. It's now 30 years this year since the working group was created by the Commission on Human Rights in 1991. And that approach has really changed dramatically from 1991 till 2021. At the beginning, we had a number of cases that came to us from Greece, from Turkey, from other states such as Colombia, where conscientious objection was the problem and may still be a problem. In those cases, the working group tended to look at the issue not in terms of depriving people of their right to have their own conscientious objections, whether based on faith or other reasons of pacifism, but looked at it in a very technical point of view, in terms of when people were being repeatedly detained for their conscientious objection, whether that constituted a violation of double jeopardy. Under international law, you are not allowed to be placed in double jeopardy, being repeatedly punished for the same offence. And that was the approach that the working group took initially. I should tell you, actually, by way of background as well, that the working group looks at detention in a very structured way. We analyse detention issues and whether it's arbitrary, because not all detention under international law is arbitrary. As you know, people do go to jail and are regularly detained, but it's firstly, when there's no legal basis for a detention, when someone's detained, for example, without an arrest warrant or stays beyond their sentence, we would say there's no legal basis. Secondly, when someone is detained for exercising their rights, such as their freedom of expression, freedom of religion, freedom of conscientious objection, if they're detained for that reason, we would call it arbitrary. Thirdly, we call arbitrary detention that's based on a situation where fair trial rights were not afforded to the particular person detained. They didn't have a lawyer. They were detained too long. There was undue delay in their matter. All of these kinds of matters that can make a fair trial unfair. Fourthly, we look at immigration detention, which is not directly relevant to conscientious objection. And fifthly, we look at discrimination. So if someone's detained for their religious beliefs, for example, we would find that to be arbitrary. So those are the 5 categories we use. And as I mentioned in the beginning of our jurisprudence, we tended to look at military conscientious objection to military service through very due process lens and whether people were in effect being punished repeatedly, so much so that it violated their rights to hold their own beliefs. Now, over the years, we came to evolve to a different position where we started to recognise, as did the Human Rights Committee that Laurel mentioned, that there is a right to conscientious objection. It's not specifically mentioned in the International Covenant on Civil and Political Rights, but it's inherent in the right to have a religious belief or conscience, thought and religion. And a lot of cases started to come to us from places like Colombia, Turkey, Israel. And the working group eventually found that there is such a right, but that when you tell a state that you're a conscientious objector, that's a manifestation of your religion or belief under Article 18.3 of the International Covenant on Civil and Political Rights, and can therefore be limited by states if necessary for reasons of national security, health, morals and order, etc. So at that point, around about the early 2000s, 2003 to 2008, our jurisprudence hadn't yet fully evolved to where it is now, but it was changing. Now, in 2018, we had a number of landmark cases, which you may have discussed in your first webinar, come to the working group from South Korea, from Jehovah's Witnesses who had been detained on the basis of their conscientious objection. And in that case, there were 2 actually, which I've given to Laurel and she can share with you later, in which the working group finally found that conscientious objection is not a manifestation of religion or belief. Rather, it's an absolutely protected right under Article 18.1 of the Covenant, which cannot be restricted by states in any way. So states can't argue that there were any reasons of national security, health, morals, etc., that would limit the right to conscientious objection. And that's the current position of the working group. It was most recently outlined in one of our annual reports in 2019. And so we have had subsequent cases to those, which we treat as being arbitrary. If someone's detained on the basis of being a conscientious objector, we consider that to be arbitrary, what we call per se. That is, in obvious violation of Article 18 of the International Covenant on Civil and Political Rights. Now, this might all sound a little bit technical, but it's actually an important move to recognising from a more procedural point of view to now recognising that the right not to be involved in the potential taking of life is so important that it needs to be subject to absolute protection, and the working group now recognises that. So that's just a very short history of the evolution of our thinking. I can certainly go into it more if anybody would like to know. But if you're conducting advocacy on conscientious objection and want to engage with the working group on arbitrary detention, I've got a couple of ideas on how you could do so. First of all, the group maintains an open door policy. So anybody, be they a state, an NGO, a family affected by detention, can come and see us when we're in session in Geneva at any time, or at the moment, set up a virtual meeting with at least one of the members to discuss concerns on a confidential basis. We also hold an annual civil society meeting in Geneva in our August session, at which we invite a lot of stakeholders to come along. I think, Laurel, we've seen you there on a few occasions in the past, and that's an important opportunity to come and tell the working group about contemporary issues that are going on conscientious objection and other human rights violations concerning detention on the ground. Laurel mentioned country visits, which are also very important. I would say, in addition to meeting with the working group during country visits, there's a step before it that's very important for your advocacy work, and that is controversial mandates like the working group. States don't always like to have arbitrary detentions pointed out, so it can be difficult from time to time to secure invitations, and there are a lot of special procedures, thematic and country, seeking country visits. So we often speak to our NGO partners and others on the ground who do important advocacy for us in actually lobbying for the state to extend an invitation to the working group to come to a country. We can't come to a country without an invitation from the state. So it's a really important means of advocacy for civil society on the ground to lobby for that potential. We tend to focus, but not exclusively, on states that have offered what's called a standing invitation to the special procedures. About probably 80 or so states have offered what's called a standing invitation to special procedures, and that means that, in theory at least, we have the right to seek an invitation at any time to come and undertake a country visit. It's not always honoured in practice because states have elections coming up, they have other special procedures visiting, but it can be useful to approach states that have that standing invitation, and you can find out whether that's the case for your country on the OHCHR website if you Google OHCHR and standing invitation. So that's a really important way of us to find out what's going on the ground in terms of COs. Other ways, in September, the working group presents its annual report to the Human Rights Council in Geneva. Last year I presented it and it was done virtually because of the pandemic, but usually the chairperson goes along in person and presents it in Geneva, and we hope that will be the case this year. In any event, whether it's in person or whether it's virtual, civil society has the right to speak very briefly, unfortunately, at those presentations and to really give their views on different human rights issues, including conscientious objections. So that's a very important opportunity. And of course, as I mentioned, if you have any particular situations of alleged violations that you know about, you can always contact the working group through our secretariat in Geneva about issuing a communication, an urgent appeal if someone's in a desperately difficult and grave health or psychological situation, or taking a longer process to actually issue an opinion on the topic. That's probably enough from me at the moment, but if anybody has any questions, I'd be happy to answer them either now or at the end of the session. Thank you.